Hi comrades, yours Kayveeyes. Today we are going to discuss about the doubts raised by our comrades which was received prior to 17th July 2022. One comrade P. Sedhu Lakshmi from Tadapallikodam HO, AP, Andhra Pradesh. She mentioned in her email that I have contacted you, sir, about the she box. My case is still under inquiry. I have suggested her what is the further action required in this case. She is also aware of all these things. That is different. And further, she is asking clarification on two more points. Number one, ad hoc termination orders were issued by our SP by Circle Office on 7/6/2022, and it was mentioned in the memo with a direction to regional office to relieve him on joining a new regular SP. The regular SP joined on 8/7/2022 after note, but the terminated SP issued Rule 16 charge sheet to one official on 7/7/2022. Kindly clarify whether he is competent to issue charge sheet after termination orders issued but before relief. He is not terminated from the department. His ad hoc arrangement is terminated. When the ad hoc arrangement is terminated, after the joining of the relinquishment, that is on 8th July 2022. He is issuing the charge sheet on 7/7/2022 on the day he was holding the position of the disciplinary authority. When he is holding the position of disciplinary authority on 7/7/2022, he can very well issue the charge sheet that cannot be disputed under the ground since his ad hoc termination order was issued much earlier. So the position is that he can issue the charge sheet on 7/7 prior to his relief. It was informed in your previous videos that one can ask time for giving any statement to IP bar ASP when he approached us to give statement about a public complaint or anything. How much time we can request, and is there any ruling to ask such time for giving statement? There is no specific ruling is available in any volumes. The statement should not be compelled as per the Supreme Court order. It should not be compelled. If you are not giving the statement, you can mention some other dates, but you cannot protract the issue. You cannot simply say you are prolonging to give the statement further and further. At one stage, you have to give the statement. At the initial stage, on the same day itself, you can say with some reason, I am not all right, I am in a perturbed mind, I am totally disturbed, I cannot give you a statement with full mental pressure. Like this, you can give the statement on the first day, but you cannot repeat the same reason on the second day or third day. Anyhow, you have to give the statement. Only at the initial stage, you can gain time for giving the statement. That's why you can use such a weapon that is very much available before that, but there is no time limit fixed in the volumes and also CCS rules. One can ask the time for a reasonable period only. So next comrade Nihil, he has not given his office address, only the email is in the message. Comrade, can we take paternity leave in spells? Paternity leave is available for the male employee when his wife delivers the baby. That is 15 days. That can be taken before or up to 6 months after the delivery. This is a paternity leave. But this paternity leave can be taken in one spell only. It cannot be taken by split. It has to be taken as one spell only as per the existing instructions. No other specific instructions have been issued, and it should be taken in one spell only. The second question he asked, an employee who promoted from GDS to MTS have 2 years of probation, and after 5 years he became PA and SA. Then again he will be in probation for 2 years. A very, very valid question. The confirmation order has to be issued only once in entire service. But probation is different. Confirmation and probations are two elements. Confirmation is only once, and probation, wherever you are going to the higher post, if the probation period is prescribed, you have to undergo the probation period, which is absolute necessary. So far the promotees are concerned, they should come out successful in the postal training center after their training. That is the minimum requirement that is required, and they have to pass the examination conducted in the postal training center at the time of training. This is as per these existing rules. Comrade Shekhar, he has also not given his address. He sent also through mail. I am Shekhar from Andhra Pradesh Postal Circle and follower of your YouTube channel. It is humbly requested to discuss the following topics in upcoming video. For reinstatement of suspension before 90 days, whether review committee is compulsory or the decision of the disciplinary authority who imposes suspension is enough. What is the vigilant mechanism to arrest irregular suspensions or reinstatement ordered by the disciplinary authority? As per 7/1/2004 DOPT orders and also as per Rule 10, the review committee should meet before the expiry of 90 days. That is one condition. And subsequently, as per Rule 10(5)(c), an order of suspension can be revoked at any time by the competent authority. If it is decided that no formal proceedings need be drawn up with a view to impose a penalty of dismissal, removal or compulsory retirement or reduction in rank. Actually, the authority who has suspended, he can revoke the suspension. That is as per Rule 10(5)(c) of the CCS rules. Under what circumstances? At the time of issuing the charge sheet, the punishment may not lead to the penalty of dismissal, removal or compulsory retirement or reduction in rank. Under these circumstances, the disciplinary authority is competent to revoke the officials if he feels so, for which the review committee is not required and he is empowered. He has to do this. So far the vigilant mechanism to arrest the irregular suspension or reinstatement ordered by the disciplinary authority, it is a vast subject. We will discuss the suspension as a separate topic and let it be for more than 40-50 minutes so that all the aspects will come under this. So we are going to discuss the other mechanism at a later stage. Whether the RTA application from activists received out counters addressed to state central organizations are to be brooked on free of cost or charges to be levied, if so the rule position. No such provision is there. For RTA application, whatever, whether he is an activist or anybody else, he has to pay the fees across the counter and he can book the article under the registered post or ordinary post. No concession is available. Only the persons who are below the poverty line, they are exempted from payment of fee for seeking any information under the Right to Information Act, and no other specific concession is available for any activist. That is the existing ruling. Suppose while addressing to central government and state government authorities by RTA activities, if you don't want to disclose his name, such provision is permissible. That is a separate topic, but no exemption of fee is eligible for them. They have to book the register articles, feed articles without furnishing their sender address over the cover, but they have to put it inside. For such provision is available only to such things only, not for everyone. In many orders issued on additional charges in the cadre of Group A, mentioned statutory powers and current duties. Is there any exact description for those who either in DOPT or DOP rail? Is RTI comes under the statutory powers. RTI will not come under the statutory powers. Whoever holding the post, they have to furnish the information. So for the statutory powers and current duties, these are all different. If a lawyer officer who is ordered to work in other higher posts, he may be given the higher post also he can officiate, or otherwise he can do the current duties also. So these should be specified by the next authority at the time of making the ad hoc arrangements orders, but RTI, it will not come under the statutory powers. Whoever holding the post, he has to furnish the information. What are the working hours of the subdivisional office and its rule position? There is no specific order prescribed office hours for the SDI, because the SDI, you cannot expect him that he should remain always in the office. He has to go on tour, and no specific orders has been issued about the prescription of SDIP working hours in the subdivisions. Whether 700 kilometer limit for excursion is one-sided travel for entire trip. So far the recreation club is concerned, the travel up to 700 kilometers means it is for the to and fro only, not for the onward journey or inward journey. It includes both. During the discussion held in last Sunday, it was mentioned that the station tenure is only for Group B and above and not for Group C. But recent RT guidelines issued by the Directorate, while letter dated 19/5/2021, it is mentioned as 6 years and no mention on applicable cadres. Is there any specific order which states the above exemption? Actually, the RT order should be referred with the 2019 orders, January 2019 orders, and the subsequent clarifications. All the posts below the gazetted post, I mean even HG1 are not non-gazetted only, they are not gazetted post. Below that, there is no station tenure. They can be rotated based on the post tenure only. There is a very specific order issued by the department, and there is no question of station tenure below the Group B, regular Group B. Even for the ASPOs, the station tenure is computed. Two tenure in one division. He can be rotated from one subdivision to another subdivision only 2 times. More than that, he cannot be deputed. Below that, there is no station tenure. This is as per the existing orders. Comrade Lakshmi Narayanan from Chennai Central. As per India Gazette 459E, new recruitment rule, Note 3, who will avail the opportunity to appear PA or SCA exam via seniority? How claim the seniority division-wise or circle-wise? 56 other division candidate also contest in my division vacancy, so division-wise merit list based on seniority is correct. Suppose division-wise list only considered how I approach, sir. Actually, I think he is mentioning about the PASA recruitment rules recently released, in which Note 3 is there. As per the Note 3, if any junior is allowed to permit the examination, the senior who is not possessing the requisite services for appearing the examination, they may also be permitted to write the examination. If his juniors are permitted to write the examination, he can also write. That is the content of that order. So far the postman is concerned, they have already given the clarification on cadre management that the selection will be made as per the divisional seniority first, and thereafter only the surplus will be filled by the circle level merit list, and the post will be filled up. But so far the cadre management for the PA, no such clarification has been issued, and hereafter the posting will be made based on the merit list of the circle level. This is the current position, and Comrade Lakshmi Narayanan will very well understand. If he is having further doubt, he is at liberty to contact me. Comrade K. Nagajayam from Tiruchirappalli. I have availed my hometown LTC during 2022. My retirement is due in May 2023. May I eligible for hometown and all India LTC during this block? Yes, even 1 month, even a day you are remaining in the next current block, you can definitely avail. You can avail both hometown as well as all India LTC. Comrade Yashir Agamat, he is also not mentioned his division. Can a GDS go outsider on PA post? No such provision. Actually, there was a proposal in the Department of Post that the GDS can be engaged in the PA vacancy and they will be paid on daily wages. But the same has not been approved by the department and still it is pending. This is the provision. And Srinivasa Rao from Karnataka. I joined the HHG 2 post. Am I eligible for HRA for HHG 2 post? As per the existing orders, the HRA is being drawn based on the pay the official draws. So the question of HHG 2 and LHG that does not arise, how much he is getting the pay. Based on this, the HRA will be drawn to him. One comrade Rishika, she is from north but she has not mentioned about the division. I have been avoided with 3 months deferring of the next increment under Rule 16. Meanwhile, I have written the AAO examination. I am confident that I will definitely qualify the examination. What will happen to the examination and my promotion? She also mentioned that her next increment has been deferred for 3 months. So this has not come into effect. When a punishment is not come into effect, whatever promotions the official is entitled in between, that should be given to the official. If any charge sheet is issued, if any charge sheet is pending, in such cases, he cannot claim promotion. But once punishment awarded, that punishment is not implemented because of the deferment with a later date. In between, if any promotion order come, it is applicable to them. If she qualify the examination, she will definitely get the AAO posting. Comrade G. Srinivasalu, LSG SPM Tadapalli Kudam in Andhra Circle. Sir, our former SPOs relieved on 11/7/2022 and he issued a charge sheet with the date on 8/7/22. Actually, he signed it on 11/7/22 hurriedly to trouble one official. DO dispatched it on 12/7/22 after 4 days. Kindly clarify whether SP can issue charge sheet just before his relief and also clarify whether a charge sheet can be dispatched after 4 days of issue. Actually, you cannot challenge it because he has put the date on 8/7, but he was remaining in the office up to 11/7 and the DO has dispatched on 12/7. The draft would have been approved on 8/7 and the formal charge sheet would have been get ready on 11th, but they should have made us 11/7 instead of 8/7, but it was not done. But you cannot challenge this point. This is very small point, but at the same time, you can ask under the RTI, ask the file note, seeking the file note of this case, so that which date he has made the office note and which date he has approved, all these particulars you can get it. If there is a considerable delay or after his relief, whether he changed the charge report, thereafter you can have a prima facie, you can question the concerned authorities, or otherwise you cannot question on this ground. You have to challenge the charge sheet based on the facts only. Another one, Comrade K. Satyanarayana, Divisional President, he is also from Thadapalli Kudam. I am very much thankful to our Comrade Thadapalli Kudam. They are asking so many questions to me. Sir, kindly clarify whether a charge sheet to an official forcibly making him as sub-offender without any relevancy can be issued after 15 years from the date of detection of fraud with an intention to harass the official. Pertinent question. The charge sheet is issued for a cause after 15 years. Highly irregular. It can be easily challenged with the available orders. As per the DOPT OM dated 23/5/2000 and also the CBC guidelines dated 3/3/1999, if the disciplinary authority is feeling the decision, some disciplinary action should be taken, that decision should be taken within 1 month from the date of detection of such fraud or complaint. Within 1 month he has to take a decision as per the CBC guidelines 3/3/1999. The entire investigation report that has to be submitted within 3 months. In case if any process of 10% verification or something is required, that should also be completed within 3 months. Thereafter, the charge sheet should be issued within 2 months from the date of the investigation report. So, this is as per the 3/3/1999 order. The charge sheet should be issued within a week from the date of decision of the disciplinary authority. When the disciplinary authority decides that he is also contributing a factor, it has to be done like this. He cannot issue a charge sheet for a case of 15 years old. It can be easily challenged by citing the relevant ruling. You can go through the CCS rules. There are many orders are available on this score, and you can refer all these things and you can come out successfully from this. And moreover, you can ask the RTA information also. You can ask the date of the fraud detected, the file note made during 15 years before. What action was taken during these 15 years to recover the amount from the main offender or subsidiary offender? But where some lacking, some other questions, there are more questions are there. You can definitely ask all the questions. And finally, you can ask when the decision of issuing a charge sheet to the official after 15 years has taken place. Everything you can ascertain under the RTA information, and based on this also you can prefer a representation to the next authority asking him to set aside the impugned irregular charge sheet issued by the disciplinary authority. Comrade Devaprada Bhattacharya, PA West Bengal Circle, Bardwan Division, an employee transferred from another office. A new assignment he was posted less than 1 year. After this, he was transferred again to another office. Now he have completed tenure and come back where he was less than 1 year. Please guide me that there is any legal complicacy because he again come back when he was last posted. If yes or not in this regard, please provide ruling in this case. Actually, I could not understand the real issue. It is not clear. However, as per the understanding I made on this case, if the official is transferred back to the old station, which he has completed only 1 year previously, that too after completion of fresh tenure, it will be treated as a fresh tenure only. He can remain, the posting cannot be challenged. It is correct as per the ruling. If a person is completed tenure, he can definitely be posted to the place where he was working previously for 1 year. There is nothing wrong. One comrade from Karnataka who don't want to disclose his name, he is seeking a question whether the association secretary can be posted to divisional office under the rotational transfers. Actually, there was one order issued during 1960s that the union office bearers, particularly the chief executive, they should not be posted in the divisional office, but that order is not in vogue. It was issued during 1950s to 1960. Thereafter, the revised RT guidelines were issued in 1981. After 1981, that is the basis for all the orders. Now the latest order is 2019. Prior to that, 1981 order is there. After 1981, no such instruction was issued as per the revised RT guidelines that the divisional office bearer should not be posted in the divisional offices. In fact, many of our comrades are working in the divisional office, and this is the present position at this juncture. One comrade from Raichur division. Two comrades came out successful in LGO examination. Rule 16 issued at the time of posting order. Now it is ordered the punishment of 3 months postponement of increment, and that punishment is also over. The SP is not giving the appointment order to him. Punishment was only 3 months decrease. It is also over. It is referred to RO. Is it correct? Actually, if the official has come out successful before the conduct of the LGO examination, so he is declared pass in the examination. In the meanwhile, a punishment was awarded to the official. During the declaration of period, he was awarded a punishment. And the punishment also over. After the punishment over, automatically the official has to be given the promotion. And yesterday I received another message from the same official. I have replied to him also, you can represent to RO. But in the meantime, yesterday he informed that RO has also clarified that he should be given the appointment order immediately. So it is a good news. Anyhow, this is a provision. Karnataka, Comrade Kodugu Srinivas. Whether the ASP headquarters can pass TA bills in respect of mail overseer and postman staff. Actually, the power for sanction of the TA bills, etc., are vested with the divisional superintendent. If there is a deputy superintendent, these powers can be vested to the deputy superintendent working there. In some exceptional cases, if the powers are vested by the regional office to sanction the TA bills by the ASP, that can be done, but generally the ASPs are not vested with the power, and the SP is the authority who is sanctioning the TA bills of the officials in the division. Comrade Dhanashwar Mohanty from Odisha. After the merger of postmaster cadre with General Line, merged with LG on 30/6/2011, and again notionally promoted to HAG2 on 1/4/2015. Actually, we have promoted and working as HAG2 from 1/11/2019. In the above case, our pay fixation will be made from the date of notional promotion from 1/4/2015 or not. Please clarify. Actually, in the orders, in the merger of postmaster cadre with General Line, in the order, it is stated that the notional benefit will be given with retrospective effect, but the financial benefits will be given from 1/11/2019. So, the official is entitled for the notional promotion from 2015. His pay has to be regulated as if he has granted HH2 promotion from 2015. Accordingly, his pay has to be fixed, but he should not be given the arrears of pay, but the arrears of pay should be given from 1/11/2019 as per the existing orders. Comrade Samir Khan from Asansar. Now GDS are not getting the increments as the verifications are not completed. Comrade, this is highly irregular. As they have been recruited as the GDS based on the recruitment rules. After they have given the provisional appointment order, they are entitled for the paid leave, they are entitled for the increment, yearly increment, etc. They should not be given the bonus. The bonus will be given after the regularization of the service, that too with retrospective effect from the date of the provisional appointment. No order is available that he should not be given the paid leave or he should not be given the TRCA for the provisional period. This is highly irregular. Kindly take it up with the circle through the circle union and see that the system is stopped forthwith. Divisional Secretary Vijayapura in Karnataka. I invited the Circuit Secretary for attending the monthly meeting. Our divisional head denied to allow him. As per 6793 orders, if the Circuit Secretary is passing through the division and the monthly meeting is going on, he can participate, for which no permission is required. You should not ask prior permission for attending your divisional meeting by your Circuit Secretary. When your monthly meeting is there, on the same day, you can ask your Circuit Secretary and take him along with you to the divisional office. If he refuses, it will be a serious problem as per the 16/7/1963 orders. As per 6/7/1963 orders, wherever the Circuit Secretary is visiting to a particular station and the date the monthly meeting is going on, he can also participate and observe the proceedings. This is the crux of the order. So if you are seeking prior permission from your divisional head, this is unwarranted, then he will definitely deny it. But if he comes surprisingly and attend your meeting, he cannot refuse him to admit, and that problem will definitely, it will be there. Karnataka Karwar Nayak. Whether is there any tenure fixed for the marketing executive, system administrator post. These are all brought under the sensitive post, and tenure observation is absolute necessary as per the 2019 orders and also the subsequent orders. Kindly pursue with your divisional head so far this issue is concerned. Comrades, these are all the questions I received through WhatsApp, through Google Form, through email, and also some of the comments in the YouTube channel. All these things I have collected, and based on this, I have given my reply to the best possible. From the beginning I am saying I am not an expert, but try to explain things as per my knowledge. Sometimes I may also be wrong. In such cases, you can definitely say I will correct myself, and also I will give the corrigendum in the next session. I hope you will like this session. Instead of live program, I am conducting this type of question and answer, so that what are all the questions it is in their minds of our comrades, they can ask, and I can also reply to them. So it is a good interaction definitely between us, and I hope it will be beneficial to most of our comrades. My fervent request, please don't simply pass on such interactive programs, and particularly this question and answer program, don't simply pass on. You can go through minutely. Inside you can go and see each and every question. At one stage it will also be useful while you are performing your office duty as the duties of the divisional union. With this, I am concluding. Thank you very much, comrade. Meet again.